The Supreme Court just ruled 8-1 in a case that directly affects what happens to your health benefits after you retire. And almost everyone covering it online is getting the actual ruling backwards. This is not a story about new protections for seniors. It is a story about the Supreme Court closing a door that many disabled retirees thought was open. A firefighter who served her city for nearly 2 decades developed a serious illness on the job and was forced into early retirement, just lost her case at the highest court in the country. 8 justices agreed on the outcome. Only one dissented. And the reasoning behind that ruling has real consequences for anyone who is disabled, anyone who is approaching retirement, and anyone who has ever assumed federal disability law would protect them after they leave the workforce. I'm Sarah from GunGuidePro, 10 years covering constitutional and legal developments, and today we are breaking down exactly what the Supreme Court ruled in Stanley versus City of Sanford, Florida. Before we go any further, subscribe to GunGuidePro right now and turn on every single notification. We are a new channel building something genuinely important here. Clear, accurate breakdowns of major legal developments without spin and without confusion. Every subscriber tells us this content matters and gives us the motivation to keep delivering this level of analysis. 2 seconds. Completely free. Hit that subscribe button. Hit that bell. Let's get into exactly what happened to Karen Stanley and why her case matters to you. Let me walk you through exactly what happened, because the facts of this case are what make the ruling so significant. Karen Stanley started working as a firefighter for the city of Sanford, Florida in 1999. At the time she started, city policy provided subsidized health insurance to retirees until age 65. Regardless of how many years they had served. In 2003, 4 years into her career, the city changed that policy. Under the new rule, only employees who served 25 years would keep that subsidized health insurance until age 65. Everyone else would receive coverage for just 24 months after leaving the job. In 2016, Stanley was diagnosed with Parkinson's disease. By 2018, after roughly 19 years of service, her condition forced her into retirement before she reached that 25-year threshold. Under the city's revised policy, that meant she would lose her subsidized health insurance after just 24 months, while colleagues who served the full 25 years would keep theirs until they turned 65. Stanley sued under the Americans with Disabilities Act, Title I, which prohibits disability discrimination in employment. Her argument was straightforward. The city's policy disadvantaged her specifically because her disability forced her out before hitting the 25-year mark that other non-disabled retirees could reach. The lower courts ruled against her. The case worked its way up through the federal court system, and the Supreme Court agreed to hear it. Drop your state in the comments right now. Are you a current or former public employee, firefighter, police officer, teacher, or any other public servant watching how disability and retirement benefit law develops? I personally read and respond to every single comment on this channel. Here is the core legal question the Supreme Court had to answer. Does Title I of the ADA, which prohibits discrimination against a qualified individual, protect someone after they have already retired? Justice Neil Gorsuch wrote the opinion of the court. The reasoning was built almost entirely on the specific language Congress used when it wrote the statute. The ADA defines a qualified individual as someone who, with or without reasonable accommodation, can perform the essential functions of a job they hold or desire. Notice the verb tense. Can perform, hold, or desire. All present tense. The court reasoned that this language was written to describe people who are currently working or currently seeking work, not people who have already left the workforce entirely. The majority reinforced that reading by looking at other parts of the ADA. The statute's reasonable accommodation requirements reference things like existing facilities and training materials, language clearly aimed at active workplaces, not former employees who are no longer present at all. The court also compared the ADA to Title VII of the Civil Rights Act, another major employment discrimination law, noting that courts have read similar present tense language in Title VII to apply primarily to current employees as well. The bottom line of the majority's holding, Title I of the ADA protects people who currently hold a job or are currently seeking one. It does not, in the court's reading, extend to discrimination claims based purely on what happens to your benefits after you have already retired. 8 justices agreed with that core conclusion. Justice Thomas, joined by Justice Barrett, agreed with the outcome but for narrower procedural reasons. Justice Sotomayor agreed that Stanley's specific case failed, but for a different reason than the majority, which I will get to in a moment. Which Supreme Court ruling from the past year do you think has been most consequential for working Americans? Drop it in the comments. I want to know what this community has been following most closely. Justice Ketanji Brown Jackson was the lone full dissenter, and her dissent is worth understanding because it captures exactly what is at stake in how broadly or narrowly courts read this kind of statute. Jackson argued that retirement benefits are not some separate, disconnected reward that exists outside of employment. They are compensation that workers earn while they are actively on the job. In her words, retirement benefits are essential building blocks of the American dream. Workers earn them while working and receive the payoff after they leave the workforce. Treating post-employment benefits as completely outside the reach of employment discrimination law, in her view, ignores how those benefits actually function as part of someone's overall compensation for the work they already did. Jackson accused the majority of using what she called a distorted lens of pure textualism, focusing narrowly on verb tense in a way that, in her view, defeats the broader purpose Congress had in passing the ADA in the first place. She argued Congress wanted to root out disability discrimination comprehensively, not leave a gap where an employer can discriminate freely the moment someone's employment ends. Justice Sotomayor partially agreed with Jackson's reasoning. She argued that when an employer changes post-employment benefits in a way that specifically disadvantages people because of decisions made while they were still working and still disabled, that is still discrimination against them in their capacity as a qualified worker, even if the actual harm shows up after retirement. What is your honest reaction to this ruling? Type text matters most. If you think the majority's approach, focusing strictly on the statute's actual language, was the right call, or type purpose matters more if you side with the dissent's broader reading. I want genuine legal debate from this community. Here is the part of this ruling that almost nobody explaining it online is covering correctly, and it matters enormously for anyone in a similar situation. This ruling did not close every possible avenue for retirees facing disability-related benefit discrimination. It closed one specific theory, discrimination based purely on what happens after you retire. But the court left an important door open. Justice Gorsuch's opinion specifically addressed a different theory. What if the city's discriminatory policy decision was actually made and applied to Stanley while she was still working and still a qualified individual under the statute? In other words, if the harm to her began while she was still employed and disabled, not just after she walked out the door for the last time, that could be a different legal question entirely. 4 justices, plus Justice Jackson in dissent, agreed that this pre-retirement theory could potentially allow a retiree to recover. Here's the catch that decided Stanley's specific case. She never raised that theory properly. Her complaint did not allege facts about when she developed her disability relative to when the harmful policy was applied to her. She did not preserve that argument on appeal to the lower court. By the time it reached the Supreme Court, it was simply too late procedurally for her to raise it, even though several justices across both the majority and the dissent thought the underlying theory had real merit. This is a critical lesson for anyone who finds themselves in a similar position. How you frame your discrimination claim from the very beginning matters enormously. a claim built around the idea that you were harmed as a disabled worker while you were still employed, rather than purely as a retiree after the fact, may have a fundamentally different legal outcome. The court also noted explicitly that this ruling does not eliminate every legal protection for retirees facing disability discrimination. Other avenues remain. The Rehabilitation Act, state anti-discrimination laws, which Stanley separately alleged under Florida law, equal protection claims under federal civil rights statutes, and the ADA's separate anti-retaliation provisions, which protect any individual, not just current qualified individuals, meaning retaliation claims related to disability discrimination complaints are not affected by this ruling at all. Which politician or lawmaker do you think is most likely to push for Congress to amend the ADA and explicitly extend Title I protections to retirees? Name them in the comments, because both the majority and the dissent agreed that Congress has the power to change this outcome through legislation if it chooses to. I want to spend a moment on something the court emphasized that has broader implications beyond just this one case: the comparison to Title VII of the Civil Rights Act of 1964. Title VII prohibits discrimination based on race, sex, religion, and national origin in employment. The court noted that Title VII uses the word employee without a specific temporal qualifier in some places. But when it links that term to present tense verbs like work and has, courts have generally read it to cover only current employees, similar to the reading the majority applied to the ADA here. Why does this matter? Because it signals how this court approaches employment discrimination statutes more broadly. When Congress writes a law using present tense language describing current job-related status, this court is signaling it will generally read that language literally, applying it to people who currently hold or are currently seeking employment, rather than extending it to cover the entire span of someone's post-employment life. That interpretive approach will likely come up again in future cases involving other employment statutes with similar present tense language. This is not just a one-off ruling about firefighters and health insurance. It is a signal about how this court reads workplace protection statutes generally. Let me bring this down to practical terms, because understanding the law only matters if you understand what it means for real decisions people are making right now. If you are currently disabled and still employed, and you are aware that your employer has or is considering a policy that will disadvantage you specifically because of your disability once you retire, document everything now while you are still working. Based on this ruling, a claim built around discrimination that occurred while you were actively employed and qualified has a fundamentally stronger legal foundation than a claim based purely on what happens after you walk out the door. If you have already retired and believe you faced disability discrimination related to your benefits, this ruling does not necessarily end your options. Consult an employment attorney about whether your specific situation fits within the pre-retirement theory the court left open, or whether state law, the Rehabilitation Act, or other federal protections might apply to your circumstances. Every case depends heavily on its specific facts and how the claim is framed. If you are an employer, particularly a public employer, this ruling does provide some legal breathing room regarding post-retirement benefit structures, but Justice Thomas's concurrence specifically noted a cautionary scenario. An employer could try to simply remove any explicit disability-based language from a retirement policy to avoid the appearance of discrimination. But the court acknowledged this creates its own messy incentive structure, and other state and federal laws may still apply regardless of how a policy is worded. For everyone watching, this ruling is a clear reminder that statutory text matters enormously in how courts decide cases, and that timing and procedural framing of a legal claim can be just as important as the substance of the claim itself. Here is the absolute bottom line. The Supreme Court ruled 8-1 that Title I of the ADA, in its current form, does not extend disability discrimination protections to retirees regarding decisions about their post-employment benefits, based on the present tense language Congress used when writing the statute. Karen Stanley lost her specific case primarily because she did not properly preserve the one theory that several justices across the ideological spectrum acknowledged could have given her a path to relief: the argument that she was discriminated against while still working and still disabled, not merely after she retired. This ruling leaves real questions open. Congress retains full authority to amend the ADA and explicitly extend its protections to retirees if lawmakers choose to do so. Other legal avenues, state law, the Rehabilitation Act, equal protection claims, and the ADA's separate retaliation protections remain available depending on the specific facts of a case. And the procedural lesson from Stanley's experience, that how and when you raise a legal theory can determine the entire outcome of your case, applies far beyond just disability law. This case matters whether or not you are currently dealing with a disability. It tells you something important about how this Supreme Court reads employment statutes, how much weight gets placed on the precise words Congress chose to use, and how critical it is to build a legal claim correctly from the very beginning if you ever find yourself in a similar situation. Here is what you do right now. First, subscribe to GunGuidePro and hit that notification bell immediately. We are a new channel, and every single subscriber gives us the motivation and resources to keep covering significant legal developments like this one with this level of depth. Second, smash that like button and share this video with anyone you know who is a public employee, anyone approaching retirement, or anyone who works in HR or benefits administration who should understand this ruling. Third, answer the questions in the comments right now. What state are you watching from? Which lawmaker do you think is most likely to push for ADA reform on this issue? And which Supreme Court ruling from this term has impacted you or your profession the most? I personally read and respond to every single comment on this channel. GunGuidePro is just getting started. Significant legal developments like this one are exactly why this channel exists. Stay informed, stay engaged. I'm Sarah from GunGuidePro. See you in the next one.